Ghislaine Maxwell, so much activity going on in this case. It's kind of hard to keep up. The courts are receiving multiple letters every day, and a new exhibit just came out, Exhibit B, that was filed by Ghislaine Maxwell's attorneys, showing this image of her having a bruise on the inside of what looks like her left eyeball. So you can see that right here. This is from a court document. And we're going to go through this letter from Ms. Sternheim, Ghislaine Maxwell's lawyer. And you can see this right here, right? Not a real good looking, looks like a bruise. Looks like a vessel popped or something is going on there. And so people are speculating about what that is. Is this some sort of a laceration? Was she hit here? Did she, is she too stressed out? Is she popping blood vessels in her eyes? Is she not getting appropriate nutrition? A lot of potential things going on here. But the point is her defense attorney is now raising the red flag, saying, hey, this is a problem. I've been telling you for months now that the conditions in this federal prison are very, very problematic. We've already heard about it, saying that the guards wake her up every 15 minutes. Ms. Maxwell made a claim that they were violating her during one of the pat downs. We know that, guards... there was sewage and stuff being backed up apparently in her toilet. She's waking up every 15 minutes. I may have already said a lot, right? The attorneys have a litany, a huge list of things that they are just not happy about. So now the attorneys are looking at this going, see, we told you so. She just got popped in the eye, or, her blood levels or something's problematic here. Judge, we're asking for your help. The judge is curious. Let's just say that. All right. So the first story comes over from the AP. Says a judge seeks answers for jail's Ghislaine Maxwell treatment. Judge ordered the government on yesterday, to explain why guards repeatedly flash light into Maxwell's cell overnight. An action her lawyers say may have led to a bruise over one of her eyes as she awaits a trial in an alleged sex trafficking conspiracy with Jeffrey Epstein. Judge Allison J issued an order after her lawyer for Maxwell complained that guards threatened to punish her client after Maxwell was unable to explain the bruise above one eye and was noticed Wednesday night when she saw her reflection in a nail clipper. Lawyer Bobbi Sternheim said the 59-year-old Maxwell may have gotten the bruise as she tries to shield her eyes from the light that awakens her every 15 minutes as the guards make sure she's breathing. Ms. Maxwell is unaware of the cause of the bruise, as reported to medical and psych staff. She has grown increasingly reluctant to report information to the guards for fear of retaliation, discipline, and punitive chores, Sternheim wrote. Maxwell has pled not guilty to sex trafficking charges, alleging she recruited teen boys. Epstein didn't kill himself back in 2019. A lawyer for Maxwell told a 3-judge panel for a Second Circuit Court of Appeals that Maxwell is being treated as if she is a suicide risk, even though she is not one. And so, as we know, when you are on suicide watch, they are making sure that you're not going to commit suicide or die by suicide. And they are checking you very frequently. You have a lot less of the same amenities that you would have. Epstein was on that, I think, once or twice. I think he may have just gotten off of that when he got deceased, let's say. And so, she's been in those higher level, stricter protocols for a long period of time. And her attorneys are now saying, well, look what you're doing. Look what you're doing to her. See? And as I've said many times, just what's so impressive about this from a defense perspective is these are just every single minor issue, every little hiccup, every sliver of any minutia. They are calling it front and center. They are making such a massive deal about it, and they're doing a great job. I mean, they're doing a magnificent job. This representation is so thorough. Every time I go on and look at a case like this, I can't. There are so many different documents flying back and forth every which way. And what's so amazing about this is not the crime of the century. Okay, this is a sex trafficking case. This is like a few people traveling around on some airplanes and sleeping with an underage person. Okay, like it's awful and not good, and I'm not excusing that, but it's not complicated. It's a relatively simple crime relative to other types of criminal charges that involve all sorts of complicated things. I mean, even the DUI case is complicated relative to this, unless this involves a lot of other things that we don't know about, right? A DUI case involves gas chromatography, and you got to do all deep dive analysis on mass spectrometry and all these different things that require a lot of depth and scientific knowledge. And it's a difficult criminal case from an intellectual perspective because there's a lot of deep dives that you can do. We saw some of this with Chauvin. A lot of the same toxicologists and the analysis that you saw in that trial are the same expert witnesses that you would hear in a DUI case. Maxwell's case has none of that, right? It's just a few people traveling around, and we've got some witnesses, some victims who say, yeah, they slept with me. They groomed me to do these things. So what's so complicated about this case? Why are there 2.7 million pages of documents in this case for a simple sex trafficking case involving 4 minor victims? Well, it's because her lawyers are blowing up the hell out of everything. I mean, every single thing that goes on. We've already talked about this earlier in the week. Bobbi Sternheim was in there, or somebody from her office was, with Ghislaine Maxwell earlier in the week having a conversation about the case. And the guards say, allegedly, that when Miss Maxwell went into the facility to have this meeting with her lawyers, she wasn't carrying documents. Then when she left, she was carrying documents, so they confiscated those things from her. Well, that's a big problem. If you are a defense lawyer and you're trying to work with your client, you give your client confidential case material, and the people who are prosecuting you, which is the government in this case, they take those documents into their possession. That's your private confidential information. They don't have any access to that. That's attorney-client privilege. Huge problem. So that happens. Then they basically are blaming Maxwell and Sternheim, saying you violated protocols. Bobbi Sternheim responds, says, the hell we are. Now you're accusing me of something, so I want all of your records about every single thing that you ever said, including what you had for breakfast that morning and whether you put butter on your toast or not, because it is now relevant. It's now accessible because you're accusing me of something. I get access to that stuff. You just opened the door on all this. And this is happening every which way you turn, every little thing that pops up. You know, and I said, I've been following this for a long period of time, right? We were talking about how often Maxwell gets access to her lawyers. And I said months ago, I said, if I was that attorney on the other end of that, I would have, an intern or somebody dedicated full-time calling Ghislaine Maxwell every 15 minutes or every hour just to make sure that you have access, right? Access to your client. Just to say, I just needed to ask her a quick question. What happened on this day? I just have a question about this sentence. And then every time that you didn't speak with her, every time that you didn't have access, you just make a log. Government denied access, denied access, denied access, denied access, denied access. Then what do you have, right? You have a failure to provide counsel. You have a right to counsel violation. And you're just seeing this. You're seeing the framework of this thing laid out every day, just one after the other. And it's impressive. It's really, really something to see. I'm trying to communicate it well. I'm not sure that I'm doing a good job of it, but from a defense perspective, this is so intense, just in terms of the sheer volume of documents. It's a sight to behold. All right, so enough of that. Let's go back to the article. It says a lawyer for the 3-judge panel already talked about that. 2 judges said that they expressed concern about the light that is flashed in Maxwell's cell at night, interrupting her sleep. Government lawyer conceded to the appeals panel that Maxwell has not been declared a suicide risk, as she argued for Maxwell to remain behind bars prior to a trial scheduled for July 12th. Defense lawyers, and we'll see if that happens, July 12th, like 2 months from now. We're almost at May. Oh my goodness. Defense lawyers have asked that the trial be delayed until next January, which is probably more likely. Remember, the government just disclosed like 2.7 million documents. Ma Fox did an analysis on that. It was like 983 feet. It'd be like one of the tallest skyscrapers in Arizona, right? If you built that amount of discovery, it's crazy. It's a lot of material for something that is not a complicated case. All right, Second Circuit, or apparently it is a complicated case, but the real question there then is why? What's so complicated about it? Who's involved? That's why everybody's so curious. What's going on here? All right, Second Circuit, in a brief order, upheld the court's decision to thrice deny Maxwell bail on the grounds that she is a flight risk. Defense lawyers offered to put up $28.5 million and hire a 24-hour armed guards to prove that Maxwell would not flee. Maxwell, U.S. citizen, also offered to renounce her British and France citizenships, but the judge still said, sorry. Appeals court directed Nathan to deal with any complaints about her sleep conditions. So we're going to take a look at the letter here in a minute. In her order on Thursday, Nathan directed the government to find out if Maxwell is being subjected to flashlight surveillance every 15 minutes at night or any other atypical flashlight surveillance. If so, the judge said, government needs to explain the basis for doing so. And whether Maxwell can be provided with the appropriate eye covering. I'm going to show you that order here in a second. Maxwell's lawyer told the Second Circuit she had to cover her eyes with a towel or socks because they didn't give her a mask. Ian Maxwell, Maxwell's brother, said in a statement that he was shocked my sister's guards didn't immediately refer her for proper medical care. Instead, he said they bullied and harassed her, effectively blaming the victim. Simple solution is to review the round-the-clock security camera footage and see what may have occurred. He added, which sounds right. Sounds pretty simple. I mean, if she's got cameras all over her, somebody should be able to scrub through that and see what's going on. He added, apart from whatever happened in this house of horrors, I can report Ghislaine's family and friends continue to support her. We are confident once this is over, it will be the prosecutor who has a proverbial black eye. Whoa, buddy boy. Whoa. Careful. Careful there. Woo. All right. So here's the letter. This came over from Bobbi Sternheim's law office. You can see this was filed yesterday, April 29th, page 1 of 4. We're not going to go through, actually, it's short. We're going to go through the 2 pages because the other 2 are exhibits, very short exhibits. So here's what we've got. Dear Judge Nathan, this is coming from Maxwell's lawyer. She's sending this to the judge. She's saying, during oral argument, Maxwell's bail appeal before the circuit, so they took this up to the appeals court. Counsel, who is not Bobbi Sternheim, so a different appeals court lawyer, said that she was improperly deprived of sleep while being detained. In the denial of her appeal, the circuit court said, to the extent that the appellant, Maxwell, seeks relief to her sleeping conditions, direct these to the district court. So the Court of Appeals is now saying, hey, if you got a problem with the sleep stuff, take it up with the district court, the lower level court, and that's what Bobbi's doing. She says, we press our concerns regarding this issue, the disruption of the sleep and the deleterious effects sleep deprivation is having on her health, well-being, and the ability to prepare for and withstand trial. Now, if she can't sleep, her health is bad, as is evident by what we see in her eyeball. Her well-being's off. We already know that. And she can't prepare for her trial. So you are violating her right to an effective defense by not letting her sleep. You see what's happening? They're just laying the framework for an appeal. So if they lose, they can say, well, of course we lost. She couldn't sleep. So how could she possibly be prepared? She couldn't. Miss Maxwell continues to be disrupted throughout the night by guards, shining a flash strobe light into her cell, claiming that her breathing must be checked. The myth that Miss Maxwell's conditions of confinement are related to her being a suicide risk was laid to rest during the oral argument. There was nothing to support that contrived claim. Miss Maxwell is classified with standard CC1MH designation, inmate with no significant mental health care. Contrary to the report that she wears an eye mask when she sleeps, which was in the government's document, that was in docket number 196 at item 4, they say that an item was neither available for purchase at the commissary nor provided to her. She resorts to using a sock or a towel to cover her eyes in an awkward attempt to shield them from disrupting illumination every 15 minutes. Last night, she was confronted by staff due to a visible bruise over her left eye. The black eye is depicted in Exhibit B. I just showed you that, but we're going to look at it again here in a minute. Despite 24/7 camera surveillance, except when guards elect to exert authority in an intimidating way off camera, as they did during Saturday's bathroom incident, no guard addressed the bruise until Miss Maxwell, who has no mirror, caught a reflection of her aching eye in the gleam of a nail clipper. At that point, staff confronted Maxwell regarding the source of the bruise, threatening to place her in the SHU if she did not reveal how she got it. Miss Maxwell is unaware of the cause of the bruise. As reported to medical and psych staff, she has grown increasingly reluctant to report information to the guards for fear of retaliation, discipline, and punitive chores. However, there is concern that the bruise may be related to the need for Maxwell to shield her eyes from the lights being projected through the cells at night. MDC routinely places inmates in SHU, which must be solitary, if they have engaged in physical altercation with other inmates to protect inmates who are the subject of abuse. It would be ironic if the MDC follows through with its threat to place her in there. It would signal that she needs protection from the very staff so intent on protecting her, since she has no contact with anyone but staff. As suggested by the circuit, we asked the court to address this. Stop the 15-minute light surveillance of Miss Maxwell or justify the need for it. Very truly yours, Bobbi Sternheim. So, right, it's a good point. It's a great point. And now that we have this little eye thing and we have the Court of Appeals ruling, they can make a big deal out about it. And here is what the judge had to say. So, judge here says, by May 5th, 2021, the government is ordered to confer with legal counsel for the prison, for the jail, and provide the court responses to the following questions. Number 1, is Miss Maxwell being subjected to flashlight surveillance every 15 minutes at night, or any other atypical flashlight surveillance? And if so, what is the basis for doing so? And if so, can she be provided with the appropriate eye covering? ordered April 29th by Allison Nathan, U.S. District Court Judge, says the government is further ordered to share its response with defense counsel before filing it on ECF so that defense counsel can indicate whether they believe any private medical information needs to be redacted before public filing, so ordered. So then the question is there going to be any private medical information in there? If not, on May 5th, then we're going to get a copy of this response, or we'll see whatever their response is. Now, I think you can sort of extrapolate where they're going with this, right? If they are checking her, they probably want to make sure she's breathing, she's not, doing anything nefarious in there. But again, every 15 minutes, I'm not sure what you can do in those intervals. Is she getting up and chiseling away at something in 14 minutes and sneaking back into bed? No, it's not enough time. But, this is, there's a lot of activity here. The Second Circuit Court says, here, we covered this earlier in the week, I think, but they filed this today. Under consideration, it's ordered, the district court orders are affirmed, bail is again denied. She expressed concern that she was being improperly deprived of sleep. And then this is the order that says that they have permission to go back to the district judge. So we have another letter here. This is a follow-up. Let me frame this out real quick. We got a back and forth that happened yesterday. So we've talked about this previously, I think earlier this week, in fact. There was this idea that there was a meeting between Bobbi Sternheim, Ms. Maxwell's lawyer, or somebody, maybe two people from her office. They went into the prison facility, or the jail. We'll call it jail. You know what I mean? If I say prison, I mean jail. Going into the jail and having a privileged meeting. And then when she left, Maxwell had documents that apparently she shouldn't have had. Bobbi Sternheim said, no, she had those documents when they came in with her, but the guards didn't check her. So that's sort of the defense here. No, I didn't give her anything. She came in with them. Typically, the guards will check so that they can do sort of an inventory. They can say, what did you come in with? Make sure that you leave. You leave with what you came in with, nothing extra. So what Ms. Sternheim is saying is that she did come in with those documents. When she left and you took them, that was a violation of attorney-client privilege. And they got a letter back. So Ms. Sternheim got a letter from the prison facility. A woman by the name of, well, we're going to get to it in the next slide, responded and said, hey, just so you know, we did actually seize these materials from Ms. Maxwell. Just wanted to let you know. Bobbi Sternheim responded, said, oh, that's a violation. Everything that you have in your file, just don't even email it. Just have U-Haul come over there and pick up all of your file cabinets because I want everything in there. And now I'm entitled to it because you're accusing me of violating protocol. So this is sort of the back and forth now that's taking place. This is now Bobbi Sternheim sending a letter over to the judge explaining what's going on, and then we're going to see the government responding back. So let's take a quick look here. You'll notice this was filed again yesterday, April 29th. It says, Dear Judge Nathan, this is signed off by Bobbi, which is Maxwell's lawyer, says, the jail legal persists in falsely accusing Ms. Maxwell's counsel of violating Brooklyn Jail's legal visit procedures. This allegation is reckless, false, and defamatory. At no time did counsel provide documents to Ms. Maxwell for her attention, and that did not originate from Ms. Maxwell. The April 29th letter from MDC Legal states that supervisory staff reviewed video surveillance footage, but notably does not state the contents of that video surveillance. Interesting. The fact that MDC Legal does not claim to have reviewed the video or report the contents of the video footage speaks volumes. Further, and contrary to the jail's letter, jail staff did in fact, quote, seize and retain Ms. Maxwell's confidential legal documents after the legal visit on April 24th. While most of those documents were returned to Ms. Maxwell, other documents, which the MDC concedes were, quote, confiscated, were not returned to her, but rather given to her counsel the next day. As previously stated, documents returned to Ms. Maxwell counsel was, quote, legal mail, which had been sent to Ms. Maxwell sometime prior to April 24th. Counsel did not bring those documents into the facility. MDC, the jail, admits and flouts the fact that guards read Ms. Maxwell's confidential materials. This is no small matter. She's absolutely right about that. Ms. Maxwell is working tirelessly to review and discuss with her attorneys literally millions of pages of documents. And literally like 2.7. Deterioration of her confidential communications with her attorney does not produce a fair and just trial. We press our request that the court direct MDC to provide Maxwell's counsel with a copy of the video recording. So, oh my gosh, that's just, right? And the court, what's the court going to do? Yeah, it's her legal documents. What are you guys reading her legal files for? What this does also is it sort of chills the prison and the government, because every time they know they're on record now. Shoot, are we gonna complain about that? Maxwell's doing something. Are we gonna complain? Don't send Bobbi a letter. Are you nuts? She's gonna make our lives miserable for the next 45 days. You out of your mind? Let her get away with whatever she wants. I don't want to open that up again, because now they're going to be looking at the video, and now they're going to look to see whether the government's characterization of the video is accurate or not. And what if it's not? What if you watch the video and it's clear as day? What if you watch it and it's clear as day that there was no transfer of documents, that Bobbi Sternheim and Maxwell's defense team did not give her a thing? The government didn't do that, but they seized those records anyways, and they read them. Oh, it's going to be good. Going to be good, my friends. All right, so here's a letter back. This is coming over from Allison Nathan, or this is from going to Judge Nathan. You can see this is filed today. So we had this one from Bobbi, filed on 4/29/21. This one filed back today from the U.S. Department of Justice, the Federal Bureau of Prisons. So this is being signed off on by Sophia Papatru, who is staff attorney over at the prison facility. So she says, all right, listen, this letter is in response to an earlier letter. So to her April 28th letter, which is the one that we do not have. But it says here, Bobbi Sternheim just fires off letters. I mean, she's just, bah, gone, gone, next one, boom, and it's just like a machine gun. So she's referring to a letter that we did not cover today, but I think we covered it earlier in the week. It's about this incident that we're talking about. So seeking the following information. So this is a letter written in response to your April 28th order, seeking the following information regarding an alleged incident at the detention center. An inventory of the items seized from Ms. Maxwell in the incident that occurred on April 24th is going to be provided to defense counsel only. A representation indicating whether any of the seized materials were duplicated in any way was undertaken in order to determine this information. So they're going to give over a representation indicating whether Ms. Maxwell is permitted to bring confidential materials to in-person meetings, what steps have been taken to ensure the confidentiality of the lawyer-client communications. And here's what they say. They say, at no point during or after the April 24th legal visit were any materials seized and retained by Brooklyn staff. Those materials that the defense counsel gave to Ms. Maxwell, contrary to the legal visit procedures, were confiscated by staff and returned to defense counsel on April 25th. So that's really what we're talking about. Did defense counsel give it to her or not? They're saying that they did. At no point were any materials seized during or after April 24th. Those materials that the defense counsel gave to Ms. Maxwell against the policies, they were confiscated by staff and returned on April 25th. Yeah, but Bobbi says that they didn't give her anything. And folks, these are lawyers. These are like high-powered lawyers and staff attorneys for the facility, right? Did she give the documents or not? Where the hell did these pieces of paper come from? Can somebody figure that out? In addition, none of Ms. Maxwell's legal materials, including those items given to her during her April 24th legal visit, were photocopied. Supervisory staff discussed the incident with staff involved and reviewed video surveillance footage. Ms. Maxwell may bring any legal materials she wishes to carry from her housing area to her in-person meetings. Pursuant to our policies, an inmate's legal materials are visually inspected for contraband by a visiting room officer. To ensure inmates do not bring unauthorized materials into the room, inmates are only allowed to remove those legal materials they brought to the legal visit. All legal visits are subject to visual monitoring only. In addition to in-person legal visits, Ms. Maxwell may request unmonitored legal calls through the unit team for 5 hours a day. Brooklyn will continue to abide by said procedures to ensure attorney-client communications remain confidential. Okay, so let's piece this together. Here on April 29th, which is when Bobbi Sternheim wrote this together, she's talking about this. MDC Legal does not claim to have reviewed the video or report the contents of the video, and the fact that they don't report the contents speaks volumes. Okay, well, they just said here that they did. Supervisory staff discussed the incident with staff involved and reviewed video surveillance footage. All right, so maybe Bobbi's off on that. Maybe they did review it. And if they did, well, then they want a copy of it, because Ms. Sternheim is saying we want all of those being sent over to us. We request the court direct them to provide Ms. Maxwell with a copy of the video recording. So hopefully the court grants that to them. Says, yep, you got it. Send that video over to the defense counsel. I'd like to see it, right? And I'm sure Bobbi would too. And what if it doesn't show her giving her any documents? And the government just sees them anyways. Oh my goodness. All right. So let's take a quick look at some questions over from watchingthewatchers.locals.com. And our first one in the house comes from Leafy Bug. It says, so the defense is trying to get the case dismissed on procedural violations, correct? What's the probability of success given the high profile nature of the case? So I would say, so sort of, right? It's a great question and you're on the right track. So I do not think that they're trying to get the case dismissed on procedural violations, right? But it's very close to that. They're trying to lay out a framework that would give them opportunities to appeal and sort of just whittle away at the government's case. So take it up, take it back down. They're trying to get certain bits of evidence thrown out. They're trying to bolster up a bunch of these arguments that Maxwell did not get a fair trial because of all of these problems that the government is responsible for. So they're sort of manufacturing situations where they can really make the government look bad and like the government is failing to deliver on its promise of providing all defendants with due process. And if that's the case, then now there's good arguments that the charges should ultimately be dismissed because they can't prove their case beyond a reasonable doubt. So, it's not one of these things that's like a technical, like this is not a technical procedural violation. That's not accurate, right? It is actually it's a procedural issue because if she's not being cared for appropriately, then that's undermining her rights to a fair trial. So I guess I kind of walk that back a little bit. Yeah, I mean, maybe dismissals on procedural violations, but I think it's more about laying a framework for sort of a future appeals. The probability of success on a dismissal is probably 0%, right? I really do not think that the government is going to dismiss this case at all, ever. They can't because there's just too much political baggage associated to it. So it's either going to be, negotiate procedural violations in exchange for a better plea deal, or it's to lay the framework for an appeal at the conclusion of a case in the event that she is convicted. Great question. We have _shade says the 27,000 papers are each all of the billionaires and politicians who she supplied girls to. High money cases on all levels, no mercy. Yeah, so it's not just 27,000, 2.7 million pages. It's a lot of billionaires and politicians, but we know there are a lot of those types of people out there who would probably love to work with her. We have Osak says, Rob, big fan. So do you think Maxwell is holding out for the same deal her boss got with witness protection? Good question, Osak. I like how you just kind of squeezed in there in the premise of that question, just a massive conspiracy theory. You sort of thinking past the sale. So do you think she's holding out for the same deal? What deal? Oh, the witness protection deal that Epstein got. Well done. Very well done. Yeah, probably. Why wouldn't you? That's a good deal. It's a good deal. Where is that guy? Costa Rica right now? Just, doing whatever he's doing. All right. We got Norovira says, Faith, have you been keeping up with your conspiracy theories? You should duck, go what an eyebruise means on a public persona involved with underaged children. I believe it means that she's marked for execution. She probably killed some of the children. What? What, Nora? Norovirus. All right. Well, you heard it. You heard it, folks. There is a weird conspiracy about that now that you mention it. I remember seeing that. Isn't there a picture, I think, of like all of the senators with a bruise on their eyes and like broken knuckles? I think I saw that on Twitter. It was like Mitch McConnell, Mitt Romney, Rubio, or some. There's a picture of that floating around. They've all got like bruised eyes, like bruised right eyes. Like what kind of weird, bizarre ceremony are they in? Anki Woe says, it is a complicated case because Ghislaine's lawyers are not just working for her, but by proxy also working for various princes, former heads of state, and other famous people. The warden is checking every 15 minutes to make sure she doesn't kill herself, while Ghislaine isn't really trying to sleep anyway because she has to make sure she doesn't get killed while sleeping. Yeah, that sounds like a living hell, doesn't it? but yeah, there's a lot of power behind her case, and it shows in the court documents. And I mean that. I mean, it's very, very impressive. There is a lot of activity going on, and it's just not in proportion to the nature of the charges. 2.7 million pages of paper for 4 victims on a sex trafficking case. Give me a break. Jeremy Matrita says, it would be a shame if the government botches Maxine's care enough to force the court to allow her to go home, and then she disappears without punishment. It would be a shame, wouldn't it, Jeremy? You're exactly right. It would be a shame. It would be a shame if anything happened to her, right? It's a real damn shame that something happened to Epstein. It would be a really, really big shame if something happened to Maxwell. We'll see what happens on this one. Chairman of board says, is it just me, or when it comes to Ghislaine Maxwell, shouldn't the goal to be to get information about what went on and who was involved more so than to just hold her accountable for her part? I mean, seriously, I'd be okay with her walking if she spills everything on everyone that was involved. So would I. Right? Look, as long as it went to the bigger fish. Okay, as long as you got something out of it, right? What Ghislaine did to those 4 women, allegedly, right, is not okay, and she shouldn't, walk away from that. That's not what I'm saying. But if Ghislaine says, if a prosecutor says, all right, Ghislaine, what do you got? She comes back and she says, all right, I'm ready to make a deal. She goes, all right, we got Hillary Clinton, Bill Clinton, we've got Bill Gates, we've got everybody, and she just rolls down the list, and you just go, everything? She goes, everything. All right, I'll draft it up. I'll sign it right here. Total immunity, whatever you want. Tell us everything. That's just having fun. That's just having fun. John Delar, 52, says, if they find out Joe Biden or Hunter Biden were on the island, they would find a way of dismissing the case, and then she would go missing. The media would ignore it. Well, wasn't Bill Clinton on that island? I mean, there's a picture of him. He's denied it unequivocally ever since, but there's pictures of that. And I think, isn't he on the flight logs with like Chris Tucker and Jackie Chan, or I think that's that movie that I love. Rush Hour, great movie. All right, so good questions. Thank you for those over from watchingthewatchers.locals.com.